a major case. We're in court right now. I mean, as we're talking to you out of our studios, we've got Jane Raskin and a team of ACLJ lawyers in Colorado, 5 ACLJ-affiliated lawyers with our team, working on a case, as I mentioned, involving whether Donald Trump's name could even appear on the ballot in Colorado. And the Secretary of State thinks she could just take him off because she thinks he created an insurrection, even though the Minnesota Supreme Court, by the way, where we're there, said, hey, wait a minute, we think that's the role that Congress should be doing. So and Congress did not do that. He was never charged with insurrection. He was never convicted of insurrection. Okay? There's no court proceeding in Jack Smith's special counsel, nothing on insurrection. So realize what you've got here is politics at its worst.
If someone swears to uphold the Constitution, they're disqualified from holding office if they go and engage in insurrection, rebellion, or aid or comfort to the enemies of the Constitution. And Donald Trump incited an insurrection.
The only person that's concluded that he's incited an insurrection by a court of law is no one. Nobody. Zero. So what this Secretary of State's doing is taking the law into her own hands, Cece. That's really what's going on here.
Absolutely. We see the liberals, again, grasping for straws as they do. They have a target on Donald Trump, and they're going to take him down and take him out any way they can. And now, this obscure kind of argument from the 14th Amendment is what they're hanging their hat on. And it is ridiculous. And like you said, he has not been charged or convicted of any of these crimes. And it is ridiculous to think that a Secretary of State can just say, hey, in my opinion, he is guilty of this. And so I'm not going to let him be on the ballot. That goes to the very core of constitutional rights.
There's another complication here. And when I say complicated, first of all, crew filed a lawsuit in this case. That is, I'm holding it in my hand. Let's put it up on the screen right now. This is filed by the organization and individuals in Colorado. And what's particularly troubling here is the Attorney General of Colorado is taking, of course, an adverse position to ours, not shocking. So it would represent the Secretary of State. But you heard what the Secretary of State said, Harry. She thinks that she can make this determination on her own.
So many liberals in particular believe they possess unilateral, unchallengeable authority to decide whom the American people can vote for. And they have decided in their own mind, however small it might be, that Donald Trump cannot run for president. And I think it is clear beyond question that this particular move is unconstitutional on their part. After all, it's up to the Colorado GOP to decide who the candidate who will be listed on the ballot, who will represent Republican values. It's not up to the Secretary of State. It's not up to the Attorney General. It's not up to elite law professors, wherever they may be coming from. So I think it's up to the ACLJ and other organizations to challenge this particular move, which is offensive to the Constitution. It's offensive to the right of free association, and basically stand in place of the people of Colorado and say, enough is enough. We will fight this all the way up to the United States Supreme Court.
Which I think if we get adverse, I think we're, I don't want to prejudge it. I'm not going to say anything disparaging, but it's going to be a tough trial in Colorado in the state court system there, you can imagine. I mean, it's going to be difficult. But we've got a great team, and I think they're going to I have no doubt they'll do a great job. But that is really only phase one of this. This is going to go to the Colorado Supreme Court, or maybe go to the Colorado Court of Appeals first, then the Colorado Supreme Court. It's going to happen quickly, folks, and then to the U.S. Supreme Court. So this thing could move in lightning speed. It's going to move in lightning speed because we're already in trial. The trial's starting today. As we're coming to you, our team's in court, even in Mountain Time. They are in court right now. So we've got 5 lawyers, ACLJ and ACLJ affiliates in Colorado right now handling this. But there's a very dangerous precedent being set here. And again, it's whether you're for Trump, against Trump, it really doesn't matter. Having these, government officials like a Secretary of State decide who the Republican Party's nominee is going to be affects your right to vote. And that's why we intervened on behalf of the Colorado Republican Party because it's the right to vote of the citizens, Cece, that has been so damaged here.
It's not just the right of the GOP, because they do have a right to pick the candidate and put them on the ballot. But then if that candidate does not get placed on the ballot, it does take the right to vote from the individual citizens, which is ridiculous that one person can make a decision, not a judge, not a jury, nothing of the sort. Just, it's my opinion that he's not fit to be on the ballot. And this is somebody, the Secretary of State, that called President Trump a liar with no respect for the Constitution. So you already know which way she's leaning.
She wants the lawsuit as cover. That's what my theory is, rather than just doing it on her own. I think if she didn't have the lawsuit, I think she'd do it on her own. But you've got 6 individual voters filed the lawsuit. They're represented by the Citizens for Responsibility and Ethics in Washington crew against Donald Trump and against the Colorado Secretary of State. But they're really not against the Colorado Secretary of State. She's taking their side, but they want an order compelling her to take Trump off the ballot. So that's what's going on here. Now, at the same time, and this is what's so interesting, and let me tell you what's going to happen. We're in an actual court proceeding, a trial where witnesses are going to be put up, cross-examination, opening statement, closing statements like you would see in any other case. The difference here is ultimate arbiter here has to be, in my view, Harry, the Supreme Court of the United States, because it's a 14th Amendment question. It's a federal question, and there's been very little litigation. I'm trying to think. On 14th Amendment, Section 3, I think it was last used in 1918.
If you look at the litigation, it's spreading in some sense like wildfire throughout the United States. There are cases in West Virginia, Oklahoma, Minnesota, you name it, and there are future cases to come. And if you look, for instance, at the Colorado case in particular, and if you look at the action of Gina Griswold, the Secretary of State, what is she trying to do? She is trying to interfere with the right of the people of Colorado to vote for a candidate of their own choice. So in essence, she is interfering with the Constitution. She is interfering with our democracy. And so one of the things to keep in mind is that if she truly believes Donald Trump is unqualified for office, then the same logic would apply to her. She should be disqualified from future offices in the state of Colorado and in the United States, one could argue.
Today is the first day of that week-long Colorado hearing. What a great time for you to become an ACLJ champion. We also just filed an amicus brief in a case in Minnesota. Taking on new cases for Jewish students that are being harassed on campus. All of this is happening simultaneously. Your support makes a huge difference. Become an ACLJ champion. Go to aclj.org/champions. That's aclj.org/champions, and you become a champion standing with the ACLJ.